making a mistrial motion, not a surprise for a defense team, but this one seems pretty serious. What's your take?
I think it is very serious, and I think the judge is seriously considering whether or not this mistrial should be granted. The defense really, I think, put up some great arguments saying that the information that they were trying to get in was barred because of hearsay, basically. And there were two main arguments they were making. One was prior inconsistent statements, and the other one was prior recorded statements. And for various reasons, the judge agreed with the defense that it shouldn't come in. Some of the issues were the fact that it wasn't under oath for one of the statements and the fact that it was hearsay for a fact. And then the prior recorded, it wasn't close in time and that it wasn't accurate. So the judge agreed. And the judge did say, as you heard in that clip, that the defense was right and that the prosecution should not try to get in the back door what they couldn't get into the front door. So good motion on the defense side. Judge told everyone to make sure that the defendant knew and understood what could happen with a mistrial. So we'll see what the judge does.
Yeah, that's the old backdoor. I mean, you know, attorneys make their living for the most part on how to get something in that they couldn't get in one way. The question is, did they go too far, and did they push to the point where it was in fact prejudicial to the defense? Hey, on the ground there, Bryson, what was the reaction in the court as this was unfolding?
A lot of unsettled between the victim side of the family, and a lot of peace and calm for Melly's family on the other side. It was definitely a lot of tension built up throughout the days leading up to the fourth day of this trial, as trial is set to begin return on Tuesday, June 20th. But it was a lot of tension that built up from day one all the way to day 4, and that was easily visible between both sides, with the victim's family very angry, very upset by the way Melly had his posture, him praying, him doing everything other than being remorseful for the loss of his best friends, YNW Juvy and YNW Sakchaser.
Yeah, there's quite the crescendo to the first week, this motion, and it still hangs in the balance. Hey, Bradford Cohen here again, former attorney for Melly. Let me ask you this. What was your involvement with him prior to this trial? And then give me your take on the legitimacy of this motion.
Sure. I was hired on the murder case along with Jason Williams. Jason Williams is now the state attorney in New Orleans. So we were on the case for about 6 months. We saw all the discovery that was provided to us, reviewed all the discovery, had a defense strategy. And I think this defense is doing a very good job with the strategy. The same strategy that we had is that, you know, they have all this information, ballistics, phone records, things like that, but they don't have anyone that can actually say that he was in that passenger seat at the time of the shooting and that he pulled the trigger. That's the difficulty in this case, is that there's a lot of technical evidence, but not a lot of eyewitness testimony, because his co-defendant, as you know, is severed, meaning he's going to be tried separately. So when you have co-defendants that are tried separately, generally speaking, each one will point the finger at the other one, and it's very difficult to have one of them convicted on that crime. That being said, this motion I thought was well thought out. I thought it was well done. I know both attorneys, and I've spoken to both attorneys in this case. I think they're both quality attorneys. They know what they're doing. They've tried big cases. I think that in this instance, they did a very nice job laying out. If the judge denies the mistrial, you have to think to yourself that there's going to be a great appeal if a conviction comes through. Mistrials are such a difficult thing for a defense attorney, especially when you feel like the matter is going in your direction. So trials, like football, are a matter of momentum. And I think that the defense has been building momentum since day one and has been doing a nice job. So now you're at this point where you're doing a nice job, and the state either purposefully or unintentionally does this thing. And it's hard to say that it's unintentional. They knew what the rules of the game were. They knew what they were allowed to do, and they broke those rules. And they broke them very significantly. So when you're a defense attorney, you almost don't want to move for a mistrial, but you have to, especially in a case like this, where it's so significant, where you're facing a possible death penalty. And in Florida, the death penalty rules have been changed from unanimously to essentially a majority of 8-4, where the juries would vote for to implement the death penalty. So it's such a huge case. You can't not move move for a mistrial. You really have to in order to preserve the appeal. But do they really want the mistrial? I don't know. I wouldn't, because I think that things are going in their favor, and we'll have to see. If it doesn't happen, they're going to have to start over from square one, pick a new jury, and now the state gets to kind of see what's going on, right? You get to see that card before they played it. So the second bite at the apple, they could clean up the case, they could now streamline it, and you'd never want that.
Yeah, it's almost like a preliminary hearing. Okay, here's our case. Maybe you can fix it next time. And real quick follow-up, Bradford. The judge could Tuesday morning rule, and this thing is done for now.
Yes, the judge could certainly grant the mistrial. And if the judge grants a mistrial, then it would be done. They'd pick a new jury. Like I said before, now you know, in playing blackjack, the whole thing is what's the undercard, right? What does the dealer have? In this case, now you kind of know what the dealer has, and you can play your hand in a different direction. So generally speaking, mistrials really benefit the state. That's why it's such a horrible thing, right? So it's their fault, it's intentional or unintentional. In this case, I think it was intentional. And now they get the benefit of it. Now, if they could prove some intentionality and they can make some sort of argument why this case shouldn't be tried again, it's very difficult to do that. But they could try. I don't think that would happen. I think that this would be a retrial, and I think the retrial would be in another couple weeks, and I think they'd pick a new jury and they'd start over again.
Well,
but it's, like I said, it's a very difficult decision.
Yeah, we're going to find out. Now we can stew over the 3-day weekend as the judge is, and see how this thing shakes out. We're going to take a break now. We have the Q&A questions all lined up. I've got them here. I've got Terry Austin, I've got Bryson, I've got Bradford. Let's take a break. We'll come right back after this.